Um, Hi everyone. Today's lesson is simply explaining the dual character of the law of succession. Uh, you'll remember in the previous section we were dealing with the law of succession, um, the general background of the law of succession, and today we are dealing with the dual character of the law of succession. In other words, we are giving a closer look at how the law of succession was applied during colonialism and how the law of succession is applied during democracy. So, starting off with the colonialism, colonialism, you'll remember in its various forms, it had a considerable effect on the development of the law in general and the law of succession in particular. So, starting off with looking at the customary law, at how the customary law was applied during colonialism, you will remember in the first occupation by Dutch, during that time, there was absolutely no recognition of the customary law. So it was not recognized. It was absent. It was only after the second occupation by British where the customary law received some form of recognition. And the reason being that the British simply used a policy of non interference with the custom and usages of indigenous people, provided that they were not repugnant to the public policy and the natural justice. So during this time, or during that time, various territories regulated the application of the customary law by their different legislation. In other words, customary law was still regulated, was still limited. It was not fully used by that time. So it was in 1927 when some different colonial laws finally consolidated with the controversial Black Administration Act. And the Black Administration Act, which is featured permanently in this module. In other words, you cannot pass this module without understanding or having the copy of that statute. So the Black Administration Act is the act that was used to manage the indigenous affairs. So as much as the Black Administration Act managed the indigenous affairs for a very long time, but it did not survive the constitutional scrutiny. In other words, during the constitution, after the constitution, it was many sections of the act were found unconstitutional. So there is a number of the sections that were found unconstitutional. For instance, taking section 23 of the Black Administration Act, that section provides for the male primogeniture rule, and the Constitutional Court, in the case of Bear versus Magistrate Khayelitsha, found that the section was unconstitutional. So the section provided for a male primogeniture rule. In other words, the rule is simply saying that for every single household, the deceased estate must not go to any female. It must go to a firstborn, a male who is a firstborn. So female were not allowed to inherit the deceased estate. For that reason, the Constitutional Court decided that the section itself is unconstitutional on the basis of the Equality Clause, Section 9 of the Constitution. So that whole section was declared unconstitutional. As much as the Act regulated the affairs, the indigenous affairs, but very little of the Act is still remaining today. So one could conclude that the customary law was taken as a stepchild of the South African law, but those were the years before, because right now there is no doubt that the customary law is still taken as a stepchild of the South African law. The customary law is now featured permanently in the South African law. In other words, it is part and parcel of the South African legal system. That is why we are saying the modern South African legal system is a mixed or is a pluralistic legal system. In other words, it is a conglomeration of the Roman Dutch law that is influenced by the English law and and also adopted legislation and court decisions. On the other hand, it is also a number of indigenous laws which are referred to as the customary law. So we've got different statutes that are also giving definitions of the indigenous law. The first one is the recognition of the customary law. The recognition of the customary law is simply explaining or defining the indigenous law as the customs and usages traditionally observed among the indigenous African people. And we also have the Law of Evidence Amendment Act, which defines the indigenous law as the law and custom as applied by black tribes in the Republic. And we also have the South African Law Reform and Commission, which defines the indigenous law and as the customs and usages traditionally observed among indigenous African people, which also form part of their culture. So this is how the dual character of, this is how the law of succession can be playing this dual character. During the colonialism, it was not recognized, and partly during the second occupation of the British, and it was only recognized during democracy after the constitution, where it was featured permanently in the South African legal system. So the next video is explaining the common law, the difference between the common law and the customary law. Thanks very much for watching the video.